Good morning, and today we're going to jump into the new topic of negotiable instruments. And I dare say that this is probably something you have zero familiarity with, and so we're really going to kind of start at the beginning. And I trust that you've read the chapter and that that's been a help to you. But I do understand that this is not something that most people walk into knowing anything about. And so I'm recording from home this morning. If you hear a dog bark or my poor sick child cough pathetically in the background, then I do apologize. But we're going to, I think, be able to cover the first part of this chapter very well. So negotiable instruments are covered under Article 3 and 4 of the UCC. To refresh your recollection, the Uniform Commercial Code has been adopted in all 50 states in some form or another. And while it is true that states can sometimes modify what the provisions of the UCC state specifically, most of the rules have been adopted exactly as they were proposed, and so it does provide a measure of uniformity across all 50 states. So Articles 3 and 4, Article 3 in particular, focuses on negotiable instruments. Article 4 talks a little more about the banking industry and how banks actually handle the negotiable instruments once they are accepted by financial institutions. So as we look at this concept, I guess the first thing for us to do is to define what is a negotiable instrument. A negotiable instrument is just a fancy name for something that you've probably had some dealing with. And one form of it, for example, would be a check. And so a check is a form of negotiable instrument, but it is not the only kind. And so we're going to look at several different kinds of negotiable instruments, especially as they might relate to business practice. So a negotiable instrument is a signed writing containing an unconditional promise to pay an exact sum of money. Now that's a definition you really need to nail down because every single part of that is significant and important. So first of all, it has to be in writing. You cannot have a negotiable instrument that is not in writing. And so the idea is that we are going to have a written instrument that is going to be a cash substitute. Now that's a very important concept, and I want you to definitely nail this down, that a negotiable instrument is a cash substitute. And in order to understand why that is or what that is, I want to give you a little bit of the history of negotiable instruments. This began way back in England. This is not an American invention. And back in the Middle Ages in England, you had a sort of emerging coinage system. And so there was not much uniformity in terms of internationally in particular, but especially even within England, you had all different kinds of sovereigns making and minting their own coins. And so you had that issue from county to county. And then you also had the issue of security, because coinage was literally coins. And so there was not paper currency at that time. There was merely coinage. And so it became heavy. It became burdensome, especially for the wealthy, to travel with their coinage, and certainly the difficulty of being robbed and having that stolen, and just the impracticality of engaging in a business transaction where you might sell a piece of land, for example, and have to give over wheelbarrowfuls of coins in order to effectuate that transaction. And so in order to shortcut the process, the lords, literally the regional sheriff and the lords of the castle would literally have a part set apart for the coins to be kept, a room, a locked, guarded room where the coins would be kept. This was the first, really the first concept of a banking system that we see in history. And so the idea was you took your coins to the local castle and you checked them in. And so you gave the guard your coins, he counted them out very carefully, and what he gave you back was a receipt. And the idea was that this receipt, saying that you now had 50 gold coins in storage at the local castle, that receipt could be transferred to someone else. And so the guard did not try to remember who gave them that receipt. There was not necessary for it to contain an identity. The idea was whoever presents that receipt is going to be given back the coins out of storage when he wants them, when he comes back to claim them. And so this was revolutionary, because for the first time you could travel with just a piece of paper that represented wealth, that represented your coinage, rather than the heavy, burdensome load of all of that weight. And so it was much safer, and it was much more convenient. And so that was the very simple beginnings of the banking system, and certainly then of the concept of negotiable instruments. Because of the fact that what was called a bill of exchange, because that could be transferred to another merchant, that really is what kind of unlocked the ability to have large-scale financial transactions and be much more practical that way. It was a way of keeping money safe in the banks while at the same time spurring business. Now, today, the concept of a negotiable instrument continues to have the same purpose, and that purpose is to serve as a substitute for cash. Now, we have paper money, and I understand it's a little lighter to carry around, but the concept is still the same. If you're going to engage in a multi-million-dollar transaction, you don't want to walk in with a briefcase full of cash. That would be raise some eyebrows if you did that. And the idea is we can accomplish the same thing with simply a piece of paper. Now, that in and of itself is a whole sea shift in history, that this would represent wealth. That's something that's not necessarily created by the government itself, that's something that just private people would write down, that could represent cash in a transaction, and that's exactly what a negotiable instrument is. So it has to be in writing, and it has to be very specific about the terms. And so it must contain what's called an unconditional promise to pay an exact sum of money. So the amount of money has to be exact, or at least able to be calculated exactly, and the promise to pay it must be unconditional. So it can't be something like, if Mike Davis mows the yard, I will pay him $5. Is that an unconditional promise to pay? Which reminds me, I think I still owe you $5 from mowing the yard, and so that's something we'll square up later. So is that an unconditional promise to pay? No, it's a conditional. It's conditioned on him mowing the yard, and so just looking at that piece of paper, it would be completely impossible to tell whether or not the yard had been mowed or not. It would require external review and investigation, and that's not what we want. That would not be a cash substitute. If I handed you a $5 bill and said, here, you can have this, do you need to go and find out anything else about that $5? Do you need to know the history of it? Do you need to know everyone else who's ever had that $5 bill? No, because it's cash. It's money right here, represented in the form of that piece of paper. Well, we're trying to get as close to that as possible when we talk about having negotiable instruments, that there is great confidence on the part of the recipient that when I get this piece of paper back, that this is going to happen. I'm going to get paid. All right. Now, there's still a whole host of questions. I understand that. Does he have the money in the bank and things like that? But there are also ways to gain assurances about those questions. And so what we want is a piece of paper that represents as close as possible to cash without the security risks of cash. Okay? So it has to be an unconditional promise to pay, and it has to be an exact sum of money. And so some of the kinds of negotiable instruments we'll look at will actually have an amount written on them. For example, a check has an amount written on it. But some of them just have a formula. And so you'll see in a loan document, for example, can a loan document be a negotiable instrument? Yes. Yes, it can. And so a promissory note, for example, is something we'll look at as a loan document. Now, is the amount exactly fixed? Yes, because it is able to be calculated. In other words, here's the amount that's loaned, and here's the amount, the rate at which interest is going to be paid. And so it's a formula. But that formula still is, on any day, any week, can be calculated down to an exact sum of money. And so that's what a negotiable instrument is. And today we're going to focus in particular on Article 3. Now, what types of instruments are out there for us to consider as a negotiable instrument? Well, the first two that we look at are called drafts and checks. And these are not promises to pay. These are orders to pay. And there is a difference. There is no promise. They're not saying, I will pay you in the future some amount of money. No, this is an order, and it's an order that you be paid a certain amount of money. You say, well, an order to who? Well, it is an order to your bank. And so there are actually three parties in a check. There are three parties. There's the drawer and the drawee, and then there's the payee. All right? And so let's look at those three. The drawer, that is you. That is you're writing the check. This is your check. So it would say Matt Davis over in the left-hand side, and it would say pay to the order of, and it would then have a name in the line. Whose name is in the line? Which party is that? Well, that's the payee. And we'll look at a check in just a moment. Matter of fact, let me just click over there and show you that this is the payee. All right? And so if we notice that in this particular example, Eastman Supply Company is the payee. And we notice that the drawee is the bank. And so that's the third party. Drawer is the writer of the check. The payee is the person who receives the funds. And the drawee is the bank. Notice, three parties on this instrument. You may not ever have noticed that. You thought, well, I thought it was me paying this person. It is, but you're not actually giving them the cash. What happens in this process? Well, it goes from you into the drawer, and then the drawer technically takes it back to your bank, stands at the counter and says, okay, bank, this is a check drawn on this bank. Will you now pay me the cash? And the bank will check your balance and then pay him the cash. And so that document, you notice there's magic language here. It says pay to the order of. And that's what makes it negotiable. It's magic language we're going to look at in just a moment. So drafts and checks are orders to pay. Three parties, the drawer, the drawee, and the payee. A check has many different kinds. And over the next couple of chapters, we're going to look at all the different kinds of checks that are out there. You have a regular personal check. There's also something called a cashier's check or a teller's check. We have traveler's checks. We have certified checks. All kinds of wonderful fun that we're going to have in looking at the different types of checks. But all of them have one thing in common, and that is they are three-party negotiable instruments. You realize that when you are the payee on a check, when you are the drawer on the check, I should say, no, yeah, I was right. When you are the payee on the check, so in this case, Eastman Supply Company, you have the right to transfer that check to someone else instead of taking it to the bank. And so if you take it to the bank, that's fine. They'll give you the cash. Or you can negotiate that. That is the process of transferring a negotiable instrument is called negotiation. Now you say, I thought negotiation was when we got together and tried to iron out the terms of a contract. Well, that's also negotiation. That's just a different kind of negotiation. And so in this context, negotiation refers to the legal process of transferring a check, ownership and right to be paid on a check to another party, a check or any other kind of negotiable instrument. So we understand that there are checks and drafts. All right, so a promissory note is the second kind of negotiable instrument that we're going to look at. A promissory note is simply a broad term for a short-term loan. And it's simply a promise that in the future I'm going to pay you a certain amount of money. A promissory note on the note itself does not say why the money is going to be paid back. There is no consideration necessary, as we would have looked at in the contract sections that we covered in Law 1. So one of the requirements for a valid contract was that there be consideration. Do I have to put in this promissory note why I'm loaning him the money and why he should be paying me back? No, you don't. Why? Well, for one thing, the fact you gave him the money and it wasn't a gift, that is consideration. And so there already is built-in consideration. But the promissory note is a special kind of legally understood and recognized negotiable instrument. And so a promissory note is a promise to pay at some point in the future. It is only a two-party instrument. There's the maker and the bearer, and we'll talk about that, sometimes referred to as the promissor and the promisee. By the way, the next couple of chapters are going to have a lot of ors and es, all right? And so it's going to have to be something that you try and keep straight. And I think some of these diagrams actually will help significantly in keeping that straight. And so it's a two-party instrument, just a maker and a bearer. And we see that another form of that would be a certificate of deposit. So let's just look at those two examples here and see what they look like. So here's a promissory note, very simple. It just says that $3,000, Whiteacre, Minnesota, April 30th, 2010, due June 29th, 2010, on or before 60 days after the date, for value received, the undersigned jointly and severally promise to pay to the order of First National Bank of Whiteacre at its office $3,000 with interest. You notice there's an interest amount written in at 8%, and it specifies that. We notice that there are co-makers here, so that means two people are signers on this note, and both are liable as co-makers. And so who's going to receive this loan back? Well, the bank. The bank has made this loan, and they've given this customer $3,000, and the customer has approximately 60 days to get this paid back. And so very simple. You notice there's not much to it. You say, well, I've seen promissory notes that are 10 pages long. Yeah, they're out there, but none of that stuff is necessary to make it legally binding. And so what is necessary alone is that there be an amount stated, a due date, and that there be any terms that on there, and then the magic language of pay to the order of. That phrase, pay to the order of, is essential in order for this to be a negotiable instrument. Without it, it's merely a private loan document, and it cannot be negotiated. All right, here's another example that a bank would issue. This is a small CD. And so if we go to the bank and say, I want to get a $5,000 CD, then at this point, the maker is actually the customer. So the customer is loaning money to the bank in this example. It's the reverse of a promissory note, right? Because you're giving the bank $5,000, and they're promising to pay you back a specific amount of interest by a certain date. So yes, a CD is a negotiable instrument. I could go down and buy a $5,000 CD, and then I could give that to my son for his birthday because he's such a wonderful young boy and mows the yard so well. All right, and so a small CD would be the reverse of the parties, but still a negotiable instrument. All right, so how do we transfer an instrument? Well, there are two ways, and the default way is an assignment, but if you do it the correct way, then you can have it negotiated. And there are great benefits to negotiating an instrument as opposed to assigning the instrument, okay? So if you mess up and you don't get the requirements for negotiation correct, then it will be considered an assignment. And you don't want that because it doesn't have all the great benefits of negotiation. All right, so what is an assignment? Well, an assignment is simply a passing of a negotiable instrument by some means other than those necessary to constitute a negotiation. So if I just gave someone the CD that I have with the bank, then that has been assigned to them. That's perfectly acceptable, perfectly legal. They have obtained some rights in the document for sure, but they might also end up with some obligations on that document. And so it's not quite as preferred. And so we can have a transfer of assignment. With an assignment, all of the rights and duties and liabilities of the original party transfer to the new party. And so the assignor and the assignee are in the same position. He doesn't get any protection. He can't say, well, I didn't know that the boy didn't mow the yard when I got this promissory note. I didn't know that the lawnmower didn't work when they sold it to him. And so things like warranties, things like defective equipment, things like failure of performance, all of those kinds of defenses can be raised to payment if you are an assignee rather than a holder, which is what you become when this has been negotiated to you. So you don't want to receive one by assignment. You want to receive it by negotiation. And so what is a negotiation? Well, this is when the transfer becomes a holder. And this can be done based on order instruments or based on bearer instruments. So I said, you know, there has to be some magic language in there. What turns it into an order instrument? What is the difference between a non-negotiable instrument written on a napkin and a negotiable instrument written on a napkin? Can a document written on a napkin be a legally recognized negotiable instrument? Yes. Well, then what makes the difference? Well, the word order. Pay to the order of. That's what creates it into an order instrument. You always wondered why that language was on there, or maybe you're questioning me whether that's really even on your check. Well, pull it out, look at it, and you're going to find pre-printed on your check the words pay to the order of. If you don't, then you might have a pretty good lawsuit against your bank or whoever sold you those checks because they're not negotiable instruments. Now, that's an order instrument. What is a bearer instrument? Some documents say pay to the order of or to bearer of, and then have the rest of the document. What is a bearer? A bearer is anyone that has it. If you have it in your possession, then you are in a sense a bearer. You may have heard of bearer bonds. And the idea with a bearer bond is that there is no verification of how you got it. If you found it on the sidewalk and you turned it into the company, they would pay you. And the idea is you can negotiate this without a signature. There doesn't need to be any chain of custody established. You don't have to prove that you received it rightfully. Now, if it's proven that you received it by theft, then that would still undercut your claim on the document. But in the absence of any proof to the contrary, you would be paid. And so a bearer instrument is very close to cash. In effect, cash is also a bearer instrument. And so there is no signature, there's no chain of custody, there's no proof of how you got it necessary in order to be paid. All right? So paying to the order or paying to bearer, if you negotiated, if you received it according to those rules, then you would become a holder. So what are the requirements for negotiability? Well, let's look at a few things here. It's basically there are 4 requirements for negotiability, and then there are a couple of exceptions to that. All right? So first of all, in order to be negotiable, it must be in writing, and it must be signed by the maker. Okay? So it must be in writing, and it must be signed by the maker or drawer. Well, let's go back and look at one and just refresh our memory here. Who is the maker? The maker is the person who is here listed as the drawer, okay? And it has to have their signature on it. Now, what was the other option there that it said? You could have it either made by the maker or the drawer. Who is the drawer in this situation? Well, again, in a check, it's the same person. But in some instances, it may not be the same person. And so if it is the maker or the drawer, you have to have your signature on there. I can't forge your signature. We're going to talk about that in some later chapters. You know, you can't. What about a stamp? Is a stamp a signature? Yes. Okay. A stamp can be a signature if it was authorized, if that's what you set up. And so it has to be signed by the maker in writing. It must contain an unconditional promise or order to pay a fixed amount of money. It can be payable on demand or at a definite time, so we have to know when it's due. And it must be payable to order or to bearer, unless it is a check. All right. So it has to have the magic language, pay to the order of. All right. So those are the 4 requirements. Has to be in writing, signed by the drawer, unconditional promise or order to pay, payable on demand or at a definite time, and payable to order or to bearer. Now let's look at a couple of exceptions and special factors here. All right. What if it has an acceleration clause? Now this would be in consideration of a promissory note or a loan, so let's look at that. What if in this document we said something like, in case of default, this loan is due immediately? So let's say it said, rather than just the whole amount being paid on 60 days, it said that $100 had to be paid every week. And a week went by and the $100 wasn't paid. Is that a default? Yes. And so at that point, the whole entire amount would become due at that moment. And so that's called an acceleration clause. By the way, almost every loan out there has an acceleration clause. And so you understand that, for example, one of the most popular ones in a home loan situation would be if the owner of the home sells the house, then the entire loan becomes due immediately. And this kind of trips people up sometimes because they think, well, I'll just let the new owner take over my bank loan. Can you do that? And the answer is no, you can't let because there's an acceleration clause. The bank did all of this background checking on you, on your credit. They didn't do all that on some new buyer. And so they don't want to continue the same loan terms to a new person. And so it will have an acceleration clause. This allows the holder to demand payment based on any conditions. And those conditions are outside of the contract. So you say, oh, aha, it said it had to be unconditional. Now all of a sudden there's a condition. Well, this one is an exception to the unconditional requirement because it can still be negotiable as long as the amount can be determined, that exactly what is due. So if the exact value can be determined and payable on a specific date, then we still have enough of the requirements for this to be considered negotiable. We'll talk about case 14.1 when we get back together next time. All right, so whoever's got that, be ready. Okay, what about an extension clause? This is the reverse of an acceleration clause. This says this loan is due on June 1st, unless an extension is granted, and then it's due on August 1st. Uh-oh, do we have a condition now? Is this going to destroy the negotiability? No, this is fine as long as it is, again, ascertainable, the exact value can be determined, and still a specific date can be determined. In those two exceptional cases, we can still have these conditions and remain negotiable. Now, let's look at one last thing here this morning before we wrap this up. What are some factors that do not affect negotiability? These are some things that you will see on a check or a negotiable instrument, but they do not affect negotiability. So let's say you forget to put a date on a check. You forget to put the date on there. And we know that one of the requirements for negotiability is that it has to be payable on demand or at a definite time. And we say, oh no, we forgot the date. So is that going to make this non-negotiable? Well, the answer is no, it is not going to destroy the negotiability because an undated check is just considered to be payable on demand. That is the default rule. And so even without a date, it can be still presented to the bank, and they will try to pay it if funds are available. Pre or post-dating checks. So people get cute sometimes, and they say, let's say the date today is February 7th, and they say, all right, I'm going to write this check, but I know I don't have enough money in my account to cover it, but I'm going to get paid on Friday. And so I will date the check February 9th, but I'm going to give it to you today. All right, so that's called a post-dated check. Now, is that going to, number one, be effective, and number two, destroy the negotiability of the document? Well, I'll answer number two first. No, it doesn't. It's an exception. It doesn't affect negotiability. And number one, the bank will still accept it. That is not an effective way to actually prevent someone from trying to present your check to the bank for payment. Unless you notify them specifically on the document that this cannot be presented before payment, and you have to notify your bank as well of the check number and of the post-dated check. And so really it's not an effective way to do that at all. Sometimes people are a little cute with that, but it doesn't actually work. All right, what about handwritten terms? Well, anything handwritten is going to outweigh anything inconsistent that is typed, okay? So the handwritten terms are considered to be more likely to have been the later thought, right? So if we printed out a document, a promissory note, and then we crossed out a provision and we hand wrote on top of it, which version of that document are we going to legally enforce? Well, we're going to legally enforce the handwritten terms, and this is generally in all contract law, and it extends to negotiable instruments. Now, it should be initialed just to make sure that this wasn't like by one of the parties after the fact, but if it is properly authenticated, then that will outweigh any kind of printed terms that you might see. And so we go in order of what was pre-printed and then to what was handwritten. This goes along with the next one here, and that is words outweigh figures. So on a check, oftentimes you will see, let me see if that, go back to the example here. I don't think they actually have the numbers on this version of the check. Oh, they do, okay. All right, so up here in the corner, we have $1,000 printed in numerals. And then down here on this line, it's spelled out 1,000 and no/100 and then a line that goes across. All right, well, let's just talk about some of those features for a minute. You ever wonder why you have to do that? Well, it's a check and a balance. Obviously, you have to think about, okay, how do I convert this number into words? And so it's just a check and a balance to make sure that what you did was correct. It's also a security feature because the numbers over here can more easily be raised. So we could make a little hat over here on the side and make that into a 7 and say, oh, it's $7,000. And it would be hard to detect. But it would be very easy to see if someone had scratched out the word 1 and written the word 7 over the top. You would notice that, okay? And so it's a security feature on the check. Well, what if they don't match? What if we have 1,000 here and 7,000 on the line down here? By the way, this happens all the time at churches. And so I've been in an offering count situation countless times where we always verify, we pay attention to those things, and you'll notice that someone writes $50 in the number line, and then they write $1,000 down here in the lower line. Now, our rule is we just go with whichever one's higher. No, we don't do that. The bank is going to go by the line down here of the written words. And so, but honestly, as a courtesy, if possible, you go back and you show the person and they, oh, I'm so sorry, I can't believe I did that. And they clarify to you and probably write you a new check. But if you present it to the bank, they will go with the handwritten terms. They will go with the words, and that will outweigh the figures. All right? What if we say something like, with interest? Is that going to affect the negotiability? Well, it does not, and in fact, it does raise the question of, well, how much interest? And we're going to talk about that later on as to what the default is. But this would trigger a default interest rate, and we're going to talk about how to calculate that later on. But because it can be calculated, it does not destroy negotiability. And what if you give someone a check that otherwise meets all of the requirements, but it says on there, non-negotiable? Does that destroy negotiability? No, it doesn't. If the other factors are present, there was a writing signed by the maker, unconditional promise, payable on demand, payable to order or bearer, then it is a negotiable instrument regardless of whatever else the document says about negotiability. And so you have to be careful in these instances that you really are putting into legal effect what you intended. Now, next time we get together, we're going to talk about a special kind of superhero. And that special kind of superhero is called HDC man. And so I know you'll be very excited to find out what is a super holder when we get back together next time.